Welcome, everybody. My name is Shayna Tabak, and I'm the co-chair of the Migration Law Interest Group of the American Society of International Law. So pleased to have this wonderful group of individuals to converse with and learn from today on our topic entitled The Inevitability of Migration Externalization. We're going to start off with quick introductions. And so looking around my screen, I'll welcome Alejandra Macias Delgadillo, who's with Asylum Access in Mexico. Emily Rio, who is with the USC School of Law, USC Gould School of Law, excuse me. Behrouz Bouchani, who is an author based in Wellington, New Zealand. Alvaro Botero, who is with the Organization of American States. He is the coordinator of the Unit of Refugees and Forced Displacement. And my partner in crime and co-convener of this panel, Professor Ian Kissel, who is at Cornell. We will just pass the baton right over to Ian, who is going to give us some context for why this question and why right now, why this question about migration externalization. And then we'll dive into some great conversation with our panelists. Thanks.
Thank you, Shayna. I also want to thank your co-chair of the interest group, Melissa Stewart, for the opportunity to contribute to organizing this panel. I think that the panelists, I'm looking forward to hearing from each of you and learning more through this session and our discussion. I'm grateful for the chance to frame the discussion, and I thought to do so by drawing on something I wrote with my colleagues Bill Freelick and Jennifer Podkul, trying to define this concept of externalization of migration control. One of the ironies in recent years is that even as a number of countries, particularly thinking of the United States and most EU member states, have developed rights-sensitive standards and procedures for assessing protection claims within their jurisdiction, they've simultaneously established barriers that prevent asylum seekers and other migrants from ever setting foot on their territories or otherwise triggering those obligations. Of course, we can talk more about some of the challenges when it comes to even basic rights protections that migrants who do reach those territories encounter. But what we've seen over recent decades is the development by states of a toolbox for preventing migration, preventing migrants, including asylum seekers, from reaching territories and triggering states' international or domestic law obligations. The externalization of migration controls, as I would define it, and as I've written with colleagues to define it, describes extraterritorial state actions to prevent migrants, including asylum seekers, from entering the legal jurisdictions or territories of destination countries or regions, or making them legally inadmissible without individually considering the merits of their protection claims. So these actions include unilateral actions by states, as well as coordinated bilateral and multilateral state engagement, and even the enlistment of private actors. This could include direct interdiction and prevention policies, as well as more indirect actions like the provision of support or assistance to security or migration management practices in and around third countries of transit. So as migration policy has become increasingly politicized, this externalization has often been deceptively framed as a security imperative or a life-saving humanitarian endeavor rather than an effort to contain migration or control migration. Control of migration flows, control of humans is cast as an effort to prevent illegal or irregular immigration or protect migrants from the dangers of the journey. Externalization to manage migration flows are often increasingly linked to the ineffectiveness of national or regional migration policies in other states of transit, for example. And over time, this phenomenon has expanded to include the systematic enlistment of third countries in preventing migrants, again, including asylum seekers, from seeking out and entering destination states. This also includes through formalized migration policies, visa regimes, various policy efforts that are ad hoc, but also systematic. So there are very serious human rights implications of all this, and very human consequences for people on the move. And we'll probably hear a lot more about that. But I wanted to just begin by providing that suggested definition and description of this phenomenon and how we've seen its expansion in recent decades. Thank you.
Thank you so much, Ian. All right, let's just dive right in, because I hope that orientation really prompted some ideas and thoughts from all of you. I know I'm really eager to hear each of our panelists' insights into this question of how migration externalization is playing out in the different contexts in which you live and work. We'll begin with Alejandra, who is an expert in regional migration, in particular in the Americas, and sits typically in Mexico City. So Mexico sits in a unique spot regionally in that it's affected by the United States politics of externalization and border control, such as the MPP, Migrant Protection Protocol, known as Remain in Mexico. And so certainly that affects Mexico's border politics to the north. But Mexico also grapples with migrant flows from its southern border. So as a state and as a significant force in regional geopolitics, Mexico is also concerned with its own capacity to admit and process migrants and asylum seekers. So in light of all that, Alejandra, I'm eager to hear how you would describe patterns of externalization playing out in Mexico, and how do they affect the lives of individual migrants who find themselves in crossing borders in and out of Mexico. And then secondly, I wonder what lessons we might learn as we look to the Mexican experience, as we consider the applicability of the experience in Mexico in other parts of the world. So I'm happy to turn it over to you, Alejandra.
Thank you, Shana. Well, I would like to start saying that if we talk about externalization in the context of migration, as extension of the border of migration controls beyond the so-called migrant receiving nations in the global north and into neighboring countries or sending the states in the global south, we can see various practices from border controls and rescue operations to measures addressing factors of migration. In a sense of externalizations, aims to contain migrants and refugees elsewhere, away from the global north. And in Mexico, two main patterns of externalizations have been developed. One of them is the migration protocols, protection protocols, and this is under which some asylum seekers protection in the USA are forced to wait for the resolution in the northern of Mexico. And the other one is Title 42, which allows to US border authorities to quickly deport foreigners without allowing them to apply for asylum. And this is on the public health grounds due to the COVID-19 pandemic. I think these are the two most prominent recent examples of externalization. But I think that I'm sure you all agree that externalizations is a serious violation of the rights of migrants and refugees, which are protected by international migrant and refugee protection regimens. But I think that over the years, migration control mechanisms have been developed using externalizations as a method. In Mexico, we have this example. We have recently witnessed as draconian mechanisms at the USA-Mexico border, which are undermining effective access to international protection for refugees. And these mechanisms are, as I said before, the two of them, the main mechanisms, Title 42 and the migration protocols, also called MPP. But if you remember that Title 42 was implemented by Trump administration and has been continued also by the Biden administration. And in the fiscal year 2022, 60% of the Border Patrol detentions ended in Title 42 removals. I think that externalization dynamics plays an important role in the practical implementation of Title 42. As collaboration with Mexico and countries of origin, this has been crucial to these implementations. The majority of persons deported under Title 42 are from Mexico and also other countries from Salvador, Guatemala, Honduras, and they are deported to Mexico. But this is because Mexico is accepting these asylum seekers. And therefore, Mexico's acceptance has been decisive. In Asylum Access Mexico, the organization that I represent, we have seen deportations of people deported from the USA to Mexico under Title 42. And also myself, I have witnessed migrants and refugees being taken by planes from the USA to the southern border in Mexico. And from there, taken in buses to the Mexican authorities to Guatemala and Honduras. These people also are from other nationalities. For example, Ecuador and Haiti were also deported on the Title 42. In their case, directly to their countries of origin. I think this bilateral collaboration within these countries also appears to have been decisive. The migration protocols was also put in place by the Trump administration and is currently under judicial review, but this force sustains asylum seekers seeking protection in the USA to wait in Mexico until their asylum proceedings are resolved. In my opinion, both of these externalization policies made the acceptance international law norms virtually absent from the lives of these refugees. Under Title 42, they were not even formally allowed to ask for asylum, and they were deported in grave violation of the no-refoulement principle, and this is very, very important. Also, MPP violates the no-refoulement principle, and it sends people to Mexico, where they can also face persecution. And it does not guarantee the due process for the asylum seekers, given the enormous difficulties for them to be supported by a lawyer, or even physical to get to the hearings. The asylum proceedings under MPP have an extremely low success rate. This violates the right to asylum and ends in expulsion, violating the no-refoulement principle. I think MPP is one of the clearest examples of externalization of borders. It depends entirely on Mexico's collaboration. Mexico is allowing asylum seekers to remain in the country, although it does necessarily guarantee their safety. I think these policies therefore not happen because the law allow them. I think it's not because we have that in the law. I think it might be helpful to reform certain international norms. For example, it could be explicitly stated in a new protocol from the 1951 Convention for Refugees, and that when a person applies for asylum in one of country, that country cannot obligate them to wait for their resolution in a third country, as currently is happening under MPP.
Thank you so much, Alejandra. For another perspective on the regional context of the Americas, we'll turn to Alvaro Botero, So Alvaro, this June, the 9th Summit for the Americas will be held in Los Angeles this year. And considering your experience in a range of roles in the Americas, looking at issues on migration, refugees, and touching on this question of externalization, I wonder whether you anticipate that states at this upcoming summit will be able to have any meaningful conversation that might allow a recalibration of some of these practices of externalization that we're hearing about, both from Alejandra and that we're all well aware of. What do you see as some of the most significant challenges and opportunities for regional collaboration? And are there any lessons that we might be able to take from South to South migration trends or innovations in the Americas? Thanks.
Thank you, Shanna. Those were many very interesting questions, so I'll do my best to try to address them all. Yes, I think the Summit of the Americas plays a great opportunity in terms of how the countries of the region have been understanding migration trends across the Americas, and in that sense, something that to take account is that the United States is the country that is chairing this important meeting between presidents of the Americas. So I mentioned that because that gives the power to the US to establish the agenda of the topics that will be discussed during the summit. As far as we know so far, there has been a couple of announcements of the White House in terms of their interest in having discussions, specific discussions on the issue of migration, and also in particular in terms of protection, especially of asylum seekers and refugees. But other than that, there hasn't been too much more information in terms of where the discussion stands and what might the other states of the America taking into account when thinking about the discussions that they are going to have in the Summit of the Americas. So in that sense, initially the information that I saw was that there was the intention to discuss about the possibility of having a regional pact on migration and protection. The most recent information seems to aim at having some sort of declaration on migration and protection. And yeah, that can give you a sense of the challenges that the US administration is foreseeing when opening such a controversial discussion with all the members of states of the Americas. So I think it's an important but at the moment that we are right now, something that I consider extremely important is the need to start to creating a framework or a framing on what that declaration or regional pact is going to look like. As Alejandra mentioned, there has been many practices by the US administration. Some of those are still taking place at the moment in terms of externalization with Mexico or with Central American states, like the asylum cooperation agreements that were signed at the end of December with the three countries of the Northern Triangle, El Salvador, Guatemala, and Honduras, and also more older practices like the ones of interdiction in the Caribbean, the Coast Guard of the US, then it seems later was replicated by Australian authorities. So this is a topic, the topic of externalization that has been, at least at the regional level, unfortunately being led mainly by the US authorities. So it's not necessarily a topic or an issue where other states are so familiar with this or trying to replicate that. And that is a good thing. And I think important lessons that we can get from South-South migration is, for example, many of the responses that Latin American states have given to Venezuelan migration in comparison to the responses that, well, or the traditional responses that we have seen from the US regarding Central American migration to external control, detention or deportation and expulsions. In the context of South America, with the case of Venezuelan migration, we have seen many Latin American countries opening their borders, allowing these people to enter their territories, to have access to different channels of migration regularization, or in some cases to have access to the recognition as refugees under the extended definition of the Cartagena Declaration. So one of the important lessons that I see from these recent trends in terms of the Venezuelan migration is that it gives you many arguments in terms of that it is possible more humane migration policies, more open policies or policies that allows more regular avenues for migrants and asylum seekers to reach countries where they can get protection. And I think it will be very important if this is going to be one of the main topics for the Summit of the Americas, that we start to create this narrative in terms of how those other channels for regular migration and for migration management can be also applied in the context of other migration flows in the region, like the case of the Haitians, Cubans, Central Americans, and Mexicans. So yeah, I think it's an interesting moment, but it is important to create the framing, because probably not all the states of the region are going to be aware of how these externalization practices look like. And the one who established the framing established the discussion too. So yeah, I'll leave it there. Thank you.
Thank you so much. A lot of food for thought, and I appreciate that orientation in particular as we it's such a nice framing as we turn to this summit in June to help us imagine what we might be able to see there and hope for. I think with that, I will turn to New Zealand, where it is a day ahead. You're 17 hours ahead of us, welcoming the author Behrooz Boochani. Behrooz, for those unfamiliar with your journalism and your writing, and in particular with your memoir, which I have here, I'll share with people, called No Friend But the Mountain. In 2013, you fled Iran in pursuit of Australia. And at that time, you were intercepted at sea and detained on the island of Manus as part of Australia's I'm using the Spanish term, excuse me, policy of Operation Sovereign Borders, which was aimed at stopping maritime arrivals of asylum seekers in Australia. You remained there for over 6 years, where you published your book and continued to write and advocate and raise awareness of the impacts of Australia's policies on individuals who are trying to seek asylum. So I think we would all really benefit and love to hear from your reflections on this lived experience of being kept out of a country where you were trying to seek asylum. Would love to hear what you learned through that experience, what your expectations were, and if you see any openings for those of us across the globe who are concerned by these policies of border control that are having such an impact on human beings. So I'll turn it to you for your insights. Thank you.
Yeah, thank you very much for having me, for inviting me to be a part of this panel. I think it's really important that so the event is in Washington, D.C. And of course, in US, just people, the media, they focus on America, US refugee and migration policy. But I think it's very important that we hear about other countries as well, other countries such as Australia, which is, in my perspective, is the worst country in terms of treating refugees and migrants in the world. I mean, in the Western European countries, Australia is the worst, and there are many, especially after 2013, they have done so much crime, in those islands that you mentioned. So I think it's very important that we share this, that people become aware of it, because I think there is a same mentality everywhere, the way they want to prevent refugees and asylum seekers to enter the countries. It's the same mentality. That's why I am very agree with Alejandra, that she mentioned about thinking or about how to change the convention 1951 to stop countries to actually send refugees and migrants to a third country. So exactly that happened in Australia, So I came to Australia in 2013. So when I arrived in Australia, it was I just found out that anyone who come to Australia after 19 July, so this the time is very historical in Australia, 19 July 2013. Anyone who come to Australia by boat, they exile them or banish them to Manus Island and Nauru Island, which are two islands in the middle of Pacific Ocean. So I was among those refugees that they banished me to that island. But I think we really don't understand this kind of policies without actually considering and thinking about colonialism and history of colonialism and colonialism mentality. So in Australia, we had a policy called a White Australia policy. So that was an official policy which started on 1901, exactly 120 years ago. So that policy continues until 1973. So just to like 50 years ago. And so they had this policy for 7 decades. And according to this policy, they prevent people from non-European ethnic or non-European countries, especially Asians. So that was an official policy in that country, that only white people are allowed to enter Australia. So of course, when that happened for decades, for 7 decades, really, we cannot think about the policies today, that effect on the political culture in Australia, that effect on, mentality in Australia, political mentality in Australia. So, and also the way Australia has been treating the Aboriginal people, I mean, the indigenous people in Australia, that effect on Australia as well. And so now they reproduce those policies again, on this century. So I mean that really we cannot talk about this important concept without think about colonialism. And now in Europe we see that, that how, so probably we will discuss this, that why and how European countries like Hungarians, they treat Middle East refugees from Middle East differently with people refugees from Ukraine. So I mean that is really important. We cannot, but generally in Australia, I think that's why I say it's very important, because Australia has become an example now, and I am sure that those policies that we see in that, especially with Trump administration, they started, they learned something from Australia. They borrowed something from Australia. So that in Australia, that anyone who come to Australia, they banish them. And still that policy exists. To Manus Island in north of Papua New Guinea, and to Nauru Island, they keep them in Christmas Island. And so that is a classic version of colonialism, So I mean, that's why I think it's important that we really look at other parts of the world as well to understand, because it is a pattern and they affect on each other, they learn from each other. So I'm very, very agree with Alejandra, if I understood what she said, that we really should think about that the countries are not allowed to banish refugees to a third country. Yeah.
Thank you so much. I feel like there's so much food for thought and sort of some really critical threads that we can draw between the experiences that we're seeing in different parts of the world, those copycat phenomenon, as it were. So hopefully we'll be able to think about that a little bit more. Before we get into that aspect of the conversation, I do want to turn to Professor Emily Rio. Professor Rio, your scholarship touches on many aspects of our conversation, but in particular, I'll highlight a recent article that you published entitled "Detention as Deterrence," which posits that one impact of immigration detention is that it's somewhat quite aligned with these conversations we're having around the externalization of migration that states have adopted. So I have a number of questions for you, but I'm curious to hear your thoughts and your reflections on our colleagues' insights here. But specifically, I wonder whether you would argue that detention is per se a method of externalization of the migration, quote unquote, problem. And also, I'll just flag that your research really delved so deeply and effectively, I found, into your individual conversations and reflections with migrants who you interviewed. And so in light of the theme of this year's ASIL meeting, thinking about the relevance and the salience of international law for individuals, I'm curious to know how you might characterize the individual impressions that you heard from migrants who were detained with regard to how these laws and policies affected their lives.
Thank you. I'm so happy to be here, to be having this conversation with everyone. The questions that you raised, Shana, are so interesting. The first one about how we might think about detention as deterrence and whether that constitutes externalization of migration control as a conceptual matter, I think is super interesting. So to the extent that, we define externalization of control broadly as containing or restricting the flow of international migrants through these policies that ensure that migrants do not or cannot arrive or to enter migrant receiving countries. Yes, I think in some respects, all deterrence policies of migrant receiving countries can be characterized as externalized control, because what those deterrence policies do is to function as a pullback that prevents people from leaving their origin countries in the first place. So I do think that it is a form of enlistment of a sort of source countries to prevent entry into traditionally migrant receiving countries. And in that sense, it is a form of outsourcing of control over international migrants. And I think that conceptualization is useful insofar as it recognizes the importance of this growing expansion of borders beyond the physical or territorial demarcation between national territories. Now, having said that, I want to actually propose one way of thinking about externalization that's perhaps a little different than the traditional framework. And by that, I mean, I think that we really ought to recognize that externalization doesn't happen in vacuum, and that we should always think about that phenomenon in relation to increased internalized control of migrants. And I think thinking about detention in that way is particularly useful because it's relatively easy, I think, for many of us to think that detention, apart from its deterrence function, is also a form of internalized social control as well, in service of many other goals. And that aspect of internalized control is particularly true of the population of immigrant detainees whom I've studied, because they're often well-settled populations in the United States who are long-term residents who have deep family ties in the US. And the reason why I think it's important to highlight that aspect of detention, at least as it takes place predominantly in the United States, is that externalized control in the form of deterrence that seeks to keep prospective or future migrants where they are in their origin communities on the one hand, and internalized control of settled migrant populations inside our borders through their confinement, I think it reflects what I like to think of as twin processes that mirror each other in many ways. And I think that's true in at least two important respects. So the first way in which externalized control and internalized control go together hand in hand is that when we see increasing surveillance and policing of migrants and these punitive enforcement policies that weaken their domestic rights in the interior of the United States, we also tend to see simultaneously a greater shifting of our responsibilities for providing international protection to migrants who are seeking to enter the country. The other way in which I think it's important to think about externalization and internalization as two sides of the same coin is that, migrants in the interior and, prospective migrants outside our borders seeking to enter, they're not two separate independent populations that are unrelated. And to me, that means these migration control policies, whether they're externalized or internalized controls, ultimately have an impact on migrants and their families and communities on both sides of the border in many sort of entangled ways that I think we should appreciate. So I think for those reasons, at least, we should be thinking about externalization in this broader context, which of course sort of then forces us to consider the relationship between international and domestic protection of rights of migrants. And that leads to the next question that you posed for me, which is about what are the individual impressions of what international law protections might mean to immigrant detainees. And I should really preface what I'm about to say by providing you a little bit more of a background in which I conducted the field work that I've done with immigrant detainees in the United States, because it's very possible and probably likely too that depending on the particular populations of detainees, their understandings and perceptions about their legal rights, whether it's domestic or international rights, that can really vary a lot, I think. So the population of detainees that have been the focus of my research by and large are immigrants who have been detained in the United States because they've been detained in the interior, not necessarily at the border seeking entry. And for that population of migrants, as I mentioned before, many of them do have deep social ties in the United States. There's different articles that I've written in addition to the article that Shana mentioned on detention as deterrence, where I've reported on the findings from this line of work based on my interviews with detainees. One that was published in a law review called Fostering Legal Cynicism Through Immigration Detention, another one that's called Legal Attitudes of Immigrant Detainees that was published in Law and Society Review, if you're interested in reading more about sort of the details of my reports on what I found. But one thing that I think is notable, going back to your question, Shana, is in terms of detainees' impressions of international law protections and what that might mean for them, there are lots of instances in which I found that the detainees would talk about their treatment in detention as inhumane, as fundamentally degrading as human beings, and some even compared it to torture, right? For example, in the context of talking about the sheer impossibility and the agony and trauma of having to carry on a daily existence, not knowing when they might be able to get out. And that's the kind of mental trauma that's been well documented, actually, in research on individuals who are experiencing indefinite confinement. So, this refrain, we're all human and we should not be treated this way, especially in the context in which, they have not committed any crimes and therefore they cannot and should not be punished, criminally punished, is something that was a recurring theme during the field work that I've done with the detainees. But in terms of their awareness about specific international protections that might be available to them, that was actually very much absent in our conversations. And I think that actually, Ian and Shana, you might disagree with me about this, but I think that absence in their level of awareness really reflects the way in which, at least in the United States, both social movements and collective action, as well as legal advocacy on behalf of detainees, tend to generally decenter international human rights as a legal hook to protect their rights. So, for example, I've been involved in a number of class action litigation in the past few years on behalf of detainees, including migrant children, and legal arguments that are made in those cases rarely ever invoke international human rights standards. And I think the same is also largely true too in terms of activism on behalf of and alongside detainees. So these, the conversations about the importance of international law protection, I don't think have really sort of made their way into or have been made integral to social and legal advocacy of detainee rights in the United States. And the other thing that I'll note, and I'll conclude with this, is that I think even when some of those conversations do make their way into legal or public discourse about the importance of international protection, most of it actually tends to be focused predominantly, if not exclusively, on asylum seekers, very narrowly defined, and not on any other groups of international migrants who might fall outside that category or characterization and but might deserve equal protection. So I think the fact that the detainees themselves don't appear to have the level of awareness and language at their disposal to talk about their experiences and their sort of expectation in terms of legal international law protection, that to me isn't necessarily surprising. And what that suggests to me is that we really have a long way to go to broaden public's understanding of the way in which the application of international human rights law standards can bring rationality and humanity to U.S. immigration detention system, and why detention should be an exception rather than the norm, not only under domestic law, but under international human rights law as well.
Thank you so much. These have all been incredibly rich contributions, and I'm so excited. I've seen so many head nods and people taking notes, and I myself have so many questions for each of you, but I really want to make sure we get to hear from each panelist and hear whether you have questions or additional comments that you'd like to share on these topics. In particular, Emily, I also just want to flag this point that you're making, which I think is such an important one, about the sort of firewall or gap that tends to exist between people who are really focused on thinking about international protections, whether they be explicitly for refugees, more broadly for migrants, the gap between those people and individuals who are the ones bringing the lawsuits in domestic jurisdictions, whether it be in the United States, in Australia, and whether there's any potential to bridge that gap in terms of bringing together domestic protections and international law protections. Obviously there's a relationship, but so often we don't see those legal arguments really very well aligned. So with that, I'm going to turn it back to all of you. I know some of you might have questions for one another. And if not, I have a number of follow-up questions for you. And just in terms of a time check, we have about 20 more minutes to engage in conversation. So let's throw out questions and keep our answers short, and know that we will continue these wonderful conversations offline in many different forums, I hope. Who might have a question? Feel free to just jump right in or let me know in the chat.
I can start us off if nobody else has a question. I don't want to take credit for this wonderful question that I'm about to pose, which actually comes from Ian, but it's given me a lot to think about, which is this. Well, actually, it starts with your question, Sheena, that you posed to us. One of those questions had to do with the fact that migration externalization has been discussed a lot by now by migrant rights advocates and also academics. And your question was whether to recognize the existence of this phenomenon of migration externalization might be politically taboo among pro-immigration politics, and whether there might be pragmatic benefits to publicly recognizing these patterns that exist. So I think from my perspective, it's really impossible. In some ways, I think externalization of control of migrants is really inevitable in some ways, in the sense that we can't really close this Pandora's box once it's been opened. So I think it's good to be transparent as much as possible about what the receiving states are doing and why, and to actually force policymakers and politicians to recognize that fact so that they can be held accountable publicly. It doesn't really matter much to me that policymakers might use this term externalization or even that framework in talking about this phenomenon, but rather to recognize the ways in which migration control has expanded so much beyond territorial borders and is impacting and imposing costs in these ways on individuals and communities around the world. And in that context, I was thinking about this question that Ian posed about whether, are there variations on externalization that could be a rights respecting part of migration governance? In other words, might there be any ways in which border externalization can be a good thing? And, an obvious sort of example through which I'm trying to think through that question that comes to mind is about the migrant protection protocol in Mexico. As it's been implemented, clearly has resulted in human rights violations of all sorts. But I wondered, and I guess maybe this question most obviously goes to Alejandra, whether there might be ways in which policy like that can actually be overhauled and reimagined and realigned to actually protect the rights of migrants in a way that would make it workable. Or is it just so fundamentally flawed structurally that there's just no way to salvage it at all, so we should abandon it altogether? Is sort of what I've been thinking through, and wanted to get Alejandra's thoughts and others too.
Alejandra.
Yeah, well, I think this example of the migration protocols protection is the best example for externalization, but I think it's a political will for the states to change this. We have this because the Mexican government is doing agreements with the with the USA government, but in my opinion, I think in Mexico, we don't have a political migration established, I think is changing every time our migration policy. And that is because we don't have this migration policy, is that because the states are violating the rights of asylum seekers and refugees. The rights of refugees and asylum seekers is to stay in the country where they when they seek asylum seeker. I think this is the most important, to protect them. And I think also it's very important that, well, in the last months or in the last years, we are facing a challenge in Mexico about detention. And I think detention, as externalization is other example, because with these policies about the Title 42 and the MPP, all the migrants and refugees who arrive to Mexico, they are identifying by the immigration authorities, and after they identify the migrants and refugees, they send to the detention centers for migrants, and then they don't have the opportunity, and also they don't have the information about the rights in Mexico. So there is a lot of lack of information for them. Also, it's very difficult for them to have access to lawyers, and in that sense, they are sending to the origin countries in violation of the no-refoulement principle. So, yeah, I think that's my answer.
Thank you. Alvaro.
Thank you, Shanna. I would also like to reflect on the comments made by Professor Rio, specifically regarding the question on if there would be any pragmatic benefit to states publicly acknowledging these patterns of externalization. And I definitely agree on the need to give more visibility of the trends that we are facing regarding externalization. One of the biggest problems that we can see regarding the treatment of migrants, even through internalized control measures or externalized control measures, it's the high levels of impunity regarding violations of the rights of immigrants, whether they happen internally in the territory of the receiving states or transit countries, or even if they happen out of their territory. So I mentioned this because if we have these high levels of impunity, there's very little incentive by the states that are promoting these practices in terms of changing the externalization practices that they are conducting with other states. If I'm not wrong, the only decision that I can think of questioning the use of externalization measures in the region in the Americas is an old decision of the Inter-American Commission on a merits case regarding the interdiction of Haitians in 1997, which goes in contradiction to a ruling of the Supreme Court of the United States. And as you can imagine, well, the United States decided to keep using these practices. So as long as politicians, civil society are not able to visibilize these practices and not just being able to get some sort of accountability in the country or the territory where they are happening, but also bringing those states in the north to the table and asking them to respond or to redress the damage or the human rights violations that they have caused, there's not going to be any significant change in this. And that is like, to put it in some terms, the magic of externalizations. States want to prevent irregular migration or asylum seekers to reach their territory, but they also want to prevent any kind of responsibility. So as Professor Rios said, they develop measures or mechanisms in order to outsource responsibility and to prevent any kind of accountability. So in that sense, I think it's extremely important to bring or to give more visibility to this topic, but also something that we have to prevent is that the measures that we are able to take in terms of accountability also cover all the actors that are behind these conducts, because it would be easier to say, okay, there are responsibility of this country of origin or the authorities that prevent these asylum seekers to leave X country. But at the end of the day, we know that there is a big geopolitical power who is moving the threats behind all this. And if we are not able to make those actors accountable, we will be crying about this in the years to come. Thank you.
Thank you. As we think about methods of accountability and in these phenomena that we're seeing across the world, I want to bring us again one more time to this question of methods for externalization that we see repeating themselves in ever more draconian and severe ways across the world. There's obviously examples that we could draw on from Europe, from Latin America. Beiruz, I wonder if you might have any insights specifically about this industry that's really evolved and is continuing to evolve around border control, and based on your experiences and what you're seeing in Australia.
Yeah, I think, as I before mentioned, they just affect on each other. In US, in Europe, in Australia, and this system really learn from each other and they share experience with each other. And now, in Europe, some countries such as Denmark, UK, they look at Australia as an example to banish refugees, to other countries, to third countries, or to even the islands. So Denmark is doing that now. Now they keep some refugees, and also other European countries, they keep refugees in islands in Greek. So I mean, they affect on each other. But one of the things is really important, I think, is border politics and border industry. In America, in US, we have that. How much Trump administration, spent to build that wall. And that is only a part of it. In Australia, they spend more than $14 billion in less than a decade. So that huge amount of money, they spend that money just on the ocean. But I mean, who is getting benefit of this? The security companies. These security companies such as G4S, which is an international company, Wilson Security, and also, IHMS, which is another company, which is a medical company. I mean, big companies, security companies are getting benefit. But in Australia, anyone who come to Australia, their policy is to just turn back the boats to Indonesia, to Sri Lanka, to other countries. But they need refugees. They need bodies to keep this industry alive, So that's why they keep some refugees always in the detention. Because that detention is an industry. People are working there. The companies are there. They make money. So for keeping that industry alive, they need some bodies to always be there. So I mean, that's why they keep people in indefinite detention for 9 years. Now we have many people, hundreds of people in Australia. They have been in the indefinite detention for more than 9 years, and many for more than 10 years. And they are innocent, just they seek asylum. So, I mean, now that, in Australia, now that they turn back the boats, so they don't have refugees anymore. So that's why even they go and take refugees from inside in the community, refugees who already are released, they are free and they are working. Sometimes they find an excuse to take them back into indefinite detention. So I mean, that became an industry, and for actually creating change, we should just follow those companies. We should target them. If we are doing advocacy or we want to really do some change. So I'm sure in US is like that. I'm sure that security companies are working there, and with the colleagues in US, in other events that I participated, I saw that people are really working on this issue. So I mean, that is really interesting, that how these systems learn from each other and share experience.
Totally. Thank you so much. Yeah, you're absolutely right. That is, there's certainly a major profit to be made from detention. And we see that in the United States. And unfortunately, based on what you're telling us, this.
Yeah, I'm sorry, I should mention this, the US has an agreement with Australia. So I'm sure you are aware of that agreement. And I mean, through this agreement, these two systems, they learn a lot from each other, because still that process is going on. I myself, I've been dealing with people in the immigration system in US for more than 4 years. So I'm not really someone who is completely out of the context in US, because now they are processing the refugees here to transfer them. At least 800 refugees were transferred to America. The refugees who were in detention in Australia, and still that is going on.
Thank you so much. Unfortunately, by my watch, we've got about 3 minutes before we need to close out. I think I'll just say thank you preliminarily and ask if anybody has any last comments they'd like to make. We didn't get to the question of whether, and maybe I'll just leave this as food for thought for the people watching this panel, is whether this conversation around externalization is applicable to the current refugee crisis that we're seeing in Ukraine, or whether there are exceptions happening in that context. I think that could be a conversation for another fruitful, rich, hour-long panel amongst these fantastic panelists. But I'll just leave it open. We've got maybe 1 more minute, 2 more minutes for any last remarks that people would like to share. I'll go maybe alphabetical order. Alejandra.
Yeah, thank you. Well, I would like to say that in title of this session, the question is whether externalization is inevitable. Well, I want to say that it's not, as long as there is a political will. We are seeing such paradigm shift right now in Europe. And this is a continent that has extensively used externalization through the last years in order to avoid the arrivals of migrants and refugees. but also we can see now that they are adopting or adequating welcome stance towards the refugee fleeing war in Ukraine. And I think the pandemic is not over. The predicted numbers of refugees from Ukraine are high, and still we see a rather adequately policy. And this provides that externalization and anti-migration practices and policies are not inevitable. Even with the context is not easy, alongs are the states are willing to do the right thing. I just would like to finish in conclusion to saying that it's necessary that we take knowledge of our producers and how they shape our policies, and that if we understand that access to international protection is not and cannot be conditioned by our perception of who we feel more close to, I think it's very important that is our moral and legal obligation to provide to everyone who needs. The stance in Europe has now adopted towards the Ukrainians, and this is a very positive development, and this is the only adequate stance that we must adopt always when refugees need protection.
Thank you. Emily. Oh, you're mute.
Sorry about that. So one thing that I've been thinking about that I'd love to have further conversations with in the future with any of you or all of you is this question that you raised, Shayna, which is, are there ways that we might be able to make international law a meaningful reality for individual migrants? And I think from the perspective, sort of at the micro level, from the perspective of individual migrants, international law and international protections and norms just seem so distant and abstract in ways that make it very difficult for them to think along those lines. And so one thing that I'll just throw out really quickly is this framework of thinking about what socio-legal scholars have framed as a dispute pyramid that has to do with the processes of naming, blaming, and claiming. And so the idea is to be able to help people to be able to identify injuries they might have suffered and to be able to give them the tools and ability to spotlight the harmful policies in place that might have injured them and to be able to facilitate their process of claiming and reclaiming their rights from the states and state entities that might have caused those injuries. And so one way to, I think, to start to think about how we might be able to make meaningful international law meaningful reality is to perhaps to think along those lines of how we might be able to get individual migrants and advocates of those migrants to think along those terms.
Thank you so much. Behrooz, I'll give you the last word.
No, I wanted to mention again in Europe that how they have been, those countries in the East, I think mostly with Hungarians and those countries, that how they were tough in front of, in public, officially and also in public, in front of Syrian refugees and the refugees who left the Middle East because of war. And now they are sharing their rooms with refugees from Ukraine. So, of course, that is great they are doing that, but that raises a question as well. So why that is different? How we should understand that, and why that happened? I think that is a question, really. It is a question that we should think about it, and we should research about it, study about it. That that is a big shift.
Definitely.
Yeah, that we are that shows that we are committed to morality, to humanity, but not for everyone.
Yep. Thank you. Well, I would be disappointed in us if we answered all the questions and didn't raise new ones. So thank you to all of you for exceeding our expectations for what we hoped to generate with this incredibly rich conversation in the panel. I'll say thank you so much on behalf of my co-chair at the Migration Law Interest Group. Ian, thank you for your partnership as chair of the Refugee Law Interest Group and your co-chair as well. And thank you to all the participants at ASIL for joining us in this conversation on the externalization of migration. And thank you to everybody. All right, I'll say goodbye and thanks.
Thank you. Thank you.
Thank you.